In what ways is like the power of the judiciary now constrained? So more specifically, like if Congress said, and this is just an example, if Congress says, the federal government, you need to enact rules that limit the amount of time a driver can operate a commercial motor vehicle, and the federal government says, that you can only drive for 8 hours. They just decided that's our decision. Can a court like sort of surgically go in and adjust the dials in that way to say, oh, you're a little low here, you're a little high here, I'm now the expert in the room? Like, what are the limits there? Does that make sense? Trucking is difficult. It's an essential industry that every corner of the nation depends on, even without knowing it. To the average consumer, the supply chain is magic, and sometimes a black hole. Products on store shelves, dinner on restaurant tables, packages on doorsteps. It's expected to be there on time, every time, and only recognized if there's a service failure. But how is a sausage made? Who's talking about the issues that matter to trucking companies?
Welcome to True North Truck Thought, or the TTT Pod for short. A monthly podcast hosted by Scopelitis Transportation Consulting and brought to you by TrueNorth Companies. We're here to demystify the magic, address the black holes, and to talk trucking to the industry we love. Whether it's the latest research, upcoming laws and rules, safety issues and solutions, or practical discussions about real-life supply chain challenges, the TTT Pod is here to help the most important industry in our country to navigate its greatest challenges and opportunities. We bring together some of the best and brightest experts to talk about and tackle some of the most pressing industry issues. So without further ado, I'm Steve Kepler.
And I'm Sean Garney. Let's get trucking. Well, the 2023-2024 Supreme Court session just ended, and it seemed like one blockbuster after another. One focus of the court this session was the extent to which the federal government has the authority to regulate industry and society. One of the most significant decisions was the Loper Bright Raimondo case, which deals with arcane aspects of the federal bureaucracy, really not seen by many, but important nonetheless. This decision has been getting a lot of press, and for good reason. In a conclusion that surprised court watchers, the court, in a 6-3 decision that landed along partisan lines, rejected the long-held Chevron Doctrine, a principle in place since 1984 that required courts to defer to federal agencies' interpretations of sometimes ambiguous statutes. This could represent a fundamental change in how rules and regulations are developed and how and when the agency is authorized to issue them. Fortunately, here to help us unpack this is Prasad Sharma. I first met Prasad when he was vice president and deputy chief counsel at the American Trucking Associations, where I worked in the policy shop. In 2015, he left the ATA as its general counsel to work for Scopelitis, Garvin, Light, Hanson, and Feary, where he's now partner. Also joining us from the TrueNorth team is EVP of Risk and Workforce Solutions and resident big thinker Bill Zenk. Bill has been instrumental in assisting motor carriers and independent contractors in developing and implementing solutions to big picture problems. So thank you, gentlemen, both for being here. We really appreciate it. I've been looking forward to this podcast since the Supreme Court decision came down, because I just can't wait to pick Prasad and Bill's brain on what all they think might be impacted here. So thanks again for coming.
Well, and thanks, guys. Again, as Sean indicated, we're really looking forward to the conversation today. And maybe to start off, Prasad, if you wouldn't mind providing a little background on what's referred to as the Chevron deference or Chevron doctrine, and how this decision by the Supreme Court impacts on it.
Well, yeah, I will. And thank you for inviting me to participate in a nerdy discussion of administrative law. I don't get to do this often, and I look forward to having my brain picked. Happy pickings. So Chevron was a 1984 Supreme Court case that decided who should interpret ambiguities or fill in gaps in statutes that were enacted by Congress, whether that should be the agencies or the courts. Under Chevron, if Congress has been clear about the statute's meaning, that's the end of the matter. But if Congress's statutes are ambiguous or silent, and courts must defer to the agency's interpretation so long as that interpretation was reasonable. And that's true even if there are other reasonable interpretations. And this is what's known as Chevron deference, that requirement that the judiciary defer to the agency's reasonable interpretation. So what does this mean? Chevron itself involved interpretation of the term new or modified stationary source under the Clean Air Act. The question there was whether a permit was required when one device in a plant could be installed or modified without meeting permit conditions, or whether all the devices in the plant could be treated as a whole to determine whether the modification increased total emissions. EPA's regulation stated that stationary source meant a plant-wide definition. So interestingly enough, Chevron was a pro-business decision. EPA's regulation was a pro-business regulation, and it was given deference. It was the EPA regulation was overturned in the circuit court. The Supreme Court decided on Chevron that it owed deference to the agency's interpretation because it was reasonable, and it was given deference.
So in that case, I'm sorry to interrupt. I just want to be clear and understand this. In that case, in the Chevron case, it was business that was arguing, "Hey, the EPA got it right."
Correct. So it was over time, business has come to abhor the Chevron deference doctrine and felt that it's kind of promoted an activist regulatory state, but the original decision was a pro-business decision.
Interesting. And the original decision was a unanimous decision as well, right?
Correct.
That
So they're just fast forwarding really quickly to in the Loper Bright case. There, the question was whether, under a statute that authorized the National Marine Fisheries Service to require fishing vessels to carry federal monitors on board to prevent overfishing, whether that, under that statute, the NMFS could charge fishing vessels for the cost of those monitors. And again, that was a question, the cost issue was not specifically addressed in the statute. The statute said the agency could require these monitors to prevent overfishing. And that's what led to this case. And ultimately what happened is, in the case, they overruled Chevron.
You know, I also thought in research, Prasad, just kind of the history around this. This happened during the nexus for this, started during the Reagan administration, right? Who, that group was very, less government, not more government. And then you fast forward this thing 40 years and it's kind of done the exact opposite. So to your point, the origination for this was very pro-business. And then in the end, there were some unintended consequences, I guess.
Yeah, I mean, I think what's happened is over the years, we've probably seen Congress legislate less or less prescriptively, and agencies have taken that opportunity to fill in gaps more under statutes. So we'll get to some of the statutes that govern motor carriers, but you can go back to statutes like the Motor Carrier Act of 1935, the Commercial Motor Vehicle Safety Act of 1984. I mean, those are the linchpins of statutes by which FMCSA issues regulations. And back then, you couldn't have anticipated the technology, the operations that we have today. And I think that's what happened with Chevron is the agencies have been, shall we say, more nimble in addressing issues that have confronted the modern economy. Congress may not have been as nimble in legislating in that area. And there's a belief that agencies have overstepped their authority and kind of taken more control than the Constitution sets forth in the separation of powers.
So when's the last time anybody accused Congress of being nimble?
Or the agencies, right?
It's been a little while, and that lack of nimbility, I don't know if that's a word, but we'll use it for now. has resulted in something like 18,000 cases. Was I reading that right? That invoke the Chevron Doctrine over the last 40 years. So that's a lot of extra nimbility. That's my final answer on that.
So yeah, I don't know the number offhand, but 18,000. I mean, it is Chevron's a pillar of administrative law. It's very often cited. So 18,000 sounds like a pretty reasonable number.
I have a memory, Prasad, years ago, sitting in your office and talking about some of the court cases that were happening around trucking, and we had a short conversation just around Chevron. Like at the end of the day, after all of this, the agencies get deference, based on their expert opinion, and it's just crazy that that's come full circle all these years later.
I'm glad you've been able to share it with me, Sean.
So maybe thanks, Prasad, for giving kind of the highlights there. So what's the significance of this decision, you think? And where do we go from here?
So I think, anytime you have a 40-year-old precedent that's been the pillar of administrative law, and you get that overturned, it's significant. But I think the ramifications of the reversal of Chevron are not quite clear, and we'll get into some of those in a bit. I think Chevron deference has not been relied on by the U.S. Supreme Court to decide a case for roughly a decade. It is, however, as Sean, as you mentioned, has been frequently used by the lower courts and continues to be frequently used up until now.
Yeah, that's crazy, and I'd like to kind of organize this conversation a little bit by talking about the background, like we talked about just now, but also sort of the impact and how the sausage is made, and then hopefully later we can speak specifically about our industry and what some of those impacts might be. Talking about some of those legislative, some of those specific pieces of legislation that you talked about. Now there was another sort of related case, which was Post versus the Board of Governors of the Federal Reserve System, which sort of will impact this conversation, I think, sort of moving forward. Can you give us just a minute or two on what that case meant and how it relates?
Yeah, just very quickly, it was a case, there was a Federal Reserve regulation that had been enacted before a company came into existence, and Corner Post then challenged that Federal Reserve regulation. And there was a ruling that it was an untimely challenge. What the Supreme Court held was that under the Administrative Procedures Act, which governs agency rulemaking, a Corner Post was entitled to a statute of limitations of up to 6 years to challenge the regulation, because that was when it came into existence was the date which the regulation harmed it, and so it had 6 years from that date, not from when the regulation was originally promulgated.
Is that a big deal? Like, it sounds like if I'm a new company, can I challenge a 40-year-old regulation because I've just been created and now I can experience that harm and then challenge that? Does that mean that the agency or whomever is going to constantly have to sort of be on their toes waiting for the next shoe to drop? Or
I think it does seem like that's going to be the case, that as regulations that have been in effect impose harm or alleged to have imposed harm on an entity, the statute of limitations by which they can bring a challenge is now more viable.
A lot longer legs then, I suppose, huh? Yeah, potentially. Well, and I'm sure people are going to try and stretch that as much as they can and try and test the system. So piggybacking off of that, Prasad, how do you think this decision will impact on how agencies approach regulatory development?
Well, I think it's obviously going to significantly cut back their leeway and authority to craft regulations. And as they craft regulations, they're going to have to spend maybe a little more time in the rulemaking process justifying the legal basis, the statutory basis for their rulemakings. And again, now they are, without deference, they have to be very persuasive to a judge that the way they are implementing the statute is the best way to interpret the statute, or to interpret what the statute authorizes the agency to do.
Yeah, there's always that section when you read final rules that talks about like statutory authority or legal authority to issue that rulemaking. So I suspect they make it longer and more detailed moving in the future. Me, as just a policy guy, typically skip that section because I found it dry and uninteresting, but maybe I should pay more attention to it now.
Well, it's often been kind of a roadmap for how to challenge a regulation if you don't like it.
From the lawyer, because he's got that figured out. That's his section. Shoot.
That's left brain, right brain stuff.
That's right. I'm going to go middle brain for me, but let's talk about sort of big picture stuff, right? Like, I studied government in college, and like generally Congress, they pass the laws, and the regulatory branch, they enforce the laws, they create the rules, right? And I've also often found, and we know at least Congress in my lifetime has not been like particularly effective, fleet of foot. The compromise has not always been their thing, especially in the last 20 years or so. And so I kind of felt my experience with government had always been like, well, a lot of times Congress decides not to make a decision because it's a little too scary, a little too controversial. And so they'll leave a little ambiguity in there. And also maybe that's because they don't have all of the necessary experts in place, right? To be able to make those specific decisions about what is the source of pollutants or whatever the case may be. And so they might sort of intentionally leave things a little bit vague with the hope that the regulatory agency picks up the slack and sort of creates something workable out of this sort of meager compromise that maybe Congress had made. That's a really big picture sort of look at it. It's always been the way I've understood things to work. Is that still the way it's going to work, or are we looking at something different? Does Congress have to change how they act too? What's the big sort of picture impacts here?
Well, as I said, the big picture impact remains a little unclear. We're going to see how it starts to play out. But I think Congress will have to change to some extent. Today a number of statutes involve vague language like safe and effective. And, prior to Loper Bright, an agency action that it reasonably interpreted to be furthering a statute's safe and effective purpose was given deference. An agency has, as you said, a number of personnel who are experts in a particular area. But now a judge is going to interpret or determine whether an action is safe and effective or furthering that congressional purpose. Congress may need to legislate with more precision and anticipate more problems that will arise in the future when it is enacting legislation.
So that's helpful context, Prasad. So do you think that this decision will just impact primarily regulations, or could people try and attack even regulatory guidance or interpretations that have been issued by a particular agency, or even decisions on contracts? Like, how deep do you think this could possibly go?
So the Chevron Doctrine itself applied only to substantive rules that have the force and effect of law. Things like interpretive rules and regulatory guidance, which explain an agency's view, but do not necessarily don't have the force and effect of law, they're analyzed under a framework established by the Supreme Court in a case called Skidmore. Under that, there's no deference, but the court can consider the agency's views based on the agency's views' power to persuade the court. So that's, I think, I hope that answers your question.
The political process is full of ups and downs, right? And I've been following this space, just through three administrations, but I've definitely seen some like ups and downs, right? Like a new administration comes in and they start making interpretations or passing rules that sort of fit with their ideology, right? A great example, I think, is like independent contractor status, where we just had the Trump rule and then the Biden rule, and sort of the ebbs and flows. And I always kind of considered that, I don't know, sort of an intentional part of our political system, right? Like a way to balance out rulemakings over the long run, right? So we go from here to there, and then eventually we kind of move towards the center as we rationalize. Some say that that was too much, that there was too much sort of ebb and flow, and that this decision and those around it might take some of that ebb and flow out, which seems kind of like a reasonable conclusion to me. Do you think that that's the case? And if so, well, the other question I had around it is, how much longer is it going to take to get anything done now? If we can't defer to people and we've got to play everything out, then how much longer does it take? So will it take the political winds out, and what's it going to do to the length of the process?
Well, I think the proponents of repealing Chevron believe that it would bring more stability to rulemaking and avoid some of the flip-flop that occurs with changes in political administrations. Whether that plays out to be true or not, we'll see. But I think, if you think about it, you were being told, the courts were being told under Chevron, there may be different reasonable interpretations. So as long as one of the interpretations the agency was propounding was reasonable, then judges had to defer to that. Now judges will be required to take on their role of interpreting statutes, and that's kind of the area that the judiciary has the expertise in interpreting statutes. You'll have an arbiter that says, okay, this is a correct interpretation of the statute, and an agency action is thus authorized, or it isn't. So maybe you will get more stability going forward.
We'll just have to work our way through all those lower courts, right? Because one might go one way and one might go the other way, depending on what is reasonable and where their ideologies lie, right? So it seems like jurisdiction is going to be super important, and that maybe we'll see those ebbs and flows somewhere else in the process.
Yeah, and I think you've seen a little bit of that play out today, even with Chevron, because I think, as I said, the Supreme Court was not utilizing Chevron to decide cases in the recent past, and I think some other judges took more care to try and interpret statutes so that they found there was no ambiguity in the first place. Remember, under Chevron, there had to be an ambiguity or a gap that the agency was filling. If the congressional statute was clear, then that was the end of the matter. And so you found some jurisdictions, some courts, some judges working harder to interpret statutes and say the statute is clear and that Chevron doesn't even apply in the first place.
Well, and the majority decision in some ways almost sounded like a reprimand of like lower courts to say, hey, y'all, you should have been doing your job this whole time. Like it's your job to interpret the laws. So get after it. Pitter patter.
And I think that's why it was phrased as a separation of powers case by the majority, saying, hey, the judiciary is entrusted with interpreting the law, and that's what we need to be doing.
Yeah. Yeah.
Well, I guess picking up on that, there's some thinking or some that think this potentially could impact on how states handle legislative actions and how things are decided at the state level from a regulatory perspective. And as we know, the the industry's long been concerned about kind of the patchwork of rules and things that happen in the Interstate Commerce Clause. Obviously, this is a federal level decision, but do you think there's potential flow down effects that could occur at the state level with this decision?
Well, most, if not all, states have their own Administrative Procedures Act. And most, if not all, states have their own kind of separation of powers under their state constitution. So they will have developed, I think a lot of states have developed a Chevron-like doctrine. This decision doesn't overturn that in any state. It is up to the state judiciary to overturn any judicial doctrine that's been developed in that state. But I think, for a large part, states have looked to federal precedent on this, and so you may see states similarly reversing any Chevron-like deference that they have incorporated in their judicial precedent.
That's interesting, Prasad. I read a bunch of analysis recently, and one of the things that I found interesting, I know Steve read the same one. In fact, he shared it with me, so I should actually give him credit for it. But I'm taking it. It's mine now.
Go
Sorry,
for it.
Steve.
That's all right. We're a team, man.
And one of the things they were talking about was that, like, over the years, Congress sort of began shedding some of their expertise, right? They began sort of letting the administrative agencies sort of be the experts in the room in that way. Do you think, I guess what I'm trying to get at is will there be fundamental changes that happen in Congress? Like, is the Congressional Review Office going to get really big? Is GAO going to take a bigger role in producing the research that can drive, agency action? We've always looked at research, especially like FMCSA and others, like all of their research. When I think about it, I think, how is this going to drive our future rulemaking? And so do you think a lot more of that will sort of shift to the legislative branch because now they're a little bit more responsible for being to articulate a specific need or a specific authority?
I think there probably will have to be some greater expertise in Congress. I think really the way to think about it is as we face problems where, again, if you're relying on older statutes and as the economy has developed and we have new technologies and we have new problems and new issues, how do we address those? And will Congress now step up and have the expertise to say, we're going to legislate on this topic, we're going to legislate on that topic, in order to give the agencies guidance to implement kind of Congress's more specific statutory mandates?
It's, Sean, kind of to that question, how I've been thinking about it a little bit is, in many ways, this is kind of an organizational system problem, right? And it's clear in the last 40 years that the growth of jobs in government has, been heavily impacted maybe by this, and thus agencies' staff requirements have grown, at least in part by this particular issue. And so the work doesn't go away, and it just potentially shifts. And there's two things that kind of come to mind for me is, one, the potential impact here kind of in a macro level is you're starting to shift the organizational structure from maybe a specialist model within these agencies to more of a generalist from a decision-making ability, within the courts and the judge system, which has pros and cons, right? Because they may see parallels across industries, but at the end of the day, they're not as close to the problem. On the flip side, if you can, build a system that puts Congress closer to the issues and accountable to the issues, there could be some substantial upside there too, because that seems to be over time deteriorating, right? So the work maybe, that's done in ultimate policy making gets closer to Congress, and they become, more attached to the real issues that drive the certain legislation. So I think it'll be interesting, and certainly this is going to be, if this sticks over time, we'll really know the impact another 40 years from now.
Mm.
If it was a better way to organize our system or not.
All right. Well, let's mark our calendars. We'll have the same conversation in 40 years.
Well, and if I can circle back, there was one thing in the Loper Bright decision. I think the court said that the best reading of the statute may be that Congress delegated discretionary authority to the agency. And if it has done so, that delegation must be respected within constitutional limits. So you may have Congress still being more explicit about, hey, we're delegating discretion to the agency to do X, Y, and Z. Now, that raises a whole nother constitutional doctrine, the potential revival of the non-delegation doctrine, which essentially says Congress cannot delegate its legislative powers or lawmaking ability to other entities. But perhaps we can leave that topic for another podcast.
Oh, goodness.
Well, it's
Oh,
interesting.
man.
Yeah, it's interesting you say that, because I was going to ask that question, picking up on Bill's point. I think the natural evolution of this could be Congress working more directly with the agencies, because right now, as we know, they do that, but it's somewhat restricted, right? There's technical assistance things that happen between. But I was going to ask that question, Prasad, if you think that will this morph, to follow up Bill's point, will this the engagement of Congress and the agencies, because the agencies have the expertise, as we know, will that require almost force them to work more collaboratively, and is that permissive? And do you see that kind of evolving at all?
I think you have to keep in mind the environment in which the reversal of Chevron occurred, and there is a certain distrust of agencies and the power that agencies have exerted. So I think that's we at least for now, that seems to be the sentiment, and that's something that I think will continue to put a premium going forward on Congress's role of lawmaking.
Yeah, it'll be interesting to see, over the long run. I think we've all probably dealt with or interacted with, congressional staffers over the years. And a lot of those folks tend to be sort of an inch deep and a mile wide. They know a lot about a little, or a little about a lot. So it'll be interesting to see sort of how that changes. But I want to move on to the sort of the trucking industry impact, sort of where the rubber meets the road. But before I do that, I'm going to pause just for a minute. Let True North tell us sort of what they got going on. So we'll take a quick pause, and we'll come back to the conversation about the impacts on our industry specifically.
Since 2001, we've been partnering with top-tier transportation firms, building custom solutions, delivering tangible results. Our mission remains steadfast: to help transportation companies like yours in protecting and maximizing assets, resources, and opportunities.
Whether you're a motor carrier, freight broker, owner-operator, or a final mile service provider, we're here to support your unique needs.
Reach out to our team of specialists to learn more about how we can tailor a comprehensive solution to meet the needs of your business.
Okay, so let's move on to our trucking industry impacts conversation. How are we going to feel this? How might we feel this in the long run? And again, to Bill's point, it could be 40 years down the line when we have this conversation again and are able to really focus on what the specific impacts might be. I've only seen a few articles in the trade press, most of which quote Prasad on this issue. So I'm glad that we have Prasad with us today to talk about this. But maybe let's start with you mentioned at the top of the podcast about the Motor Carrier Safety Act of 35 and 84 and all of those sort of authorizing statutes. I did do a little bit of research this morning, sort of going through the statutory code and sort of trying to map that to some of the big deal regulations that we know of, like hours of service and CDLs and all of that. So maybe we'll start just at the beginning about some of those authorizing statutes and, how strong they might be to weather the storms. Are there any specific regulatory impacts that you might see moving forward, just generally speaking?
Yeah, so again, and I wish I could give you something very definitive, but we're going to see how it's going to depend by judge, I think, by court. I think the thing to remember is you look at most, as we said, most trucking safety regulations are under a couple of major statutes. One is the Motor Carrier Safety Act of '84, which requires the Secretary to prescribe regulations on CMV safety and minimum safety standards for CMVs. So it establishes a couple of buckets of regulations where the Secretary shall ensure that regulations are prescribed. And you can find those at 49 U.S.C. 31136. They involve broad categories like how CMVs are maintained, equipped, loaded, and operated. And there's prescribed regulations on operators of CMVs so that they do not impair their ability to operate CMVs safely. As you know, HOS was authorized by the Motor Carrier Act of '35, which authorized the Secretary to prescribe requirements for qualifications and maximum hours of service of employees and safety operation equipment of a motor carrier. So those are broad statutes, and you can see those statutes leave a lot of room for gap filling. And then you look at, okay, well then when we started talking about ELDs, well, Congress got more prescriptive, right?
Yes. ELDs, the clearinghouse, extremely prescriptive, right?
Right, and those were, shall we say, politically controversial issues. Congress stepped in and was very more prescriptive in those areas. So that may be the model for what we see. You see these general statutes. Agencies are going to still continue to fill gaps, and they will make the case that what we're doing is consistent with the general provisions of these statutes and the best reading of it. In other cases, you may see Congress get more prescriptive. I think one area that's a hot button is CARB. California Air Resources Board is implementing a lot of regulations. One is the Advanced Clean Fleets Regulation. And there's a general preemption against emission standards for new states can't create emission standards for new vehicles. CARB has applied for a waiver of preemption under Section 209B of the Clean Air Act. And EPA can grant the waiver unless the state doesn't need the standards to meet compelling extraordinary conditions and do not provide adequate lead time to develop the technology giving consideration to the cost of compliance. So this is an area, and keep in mind, the Clean Air Act only gave this authority to request waivers to California. Other states can adopt whatever California itself promulgates, but other states have no authority to create their own emission standards for new vehicles. So on the Advanced Clean Fleets rule, CARB has applied to EPA for a waiver. EPA is now considering that waiver. Chevron deference may impact how EPA goes about that, because one thing you've had is CARB has had EPA has had a couple of different views of whether to grant a waiver for various clean car programs coming out of California. Early during the Obama administration, EPA granted a waiver to California for its Clean Cars initiative. That waiver was revoked during the Trump administration. And they interpreted the criteria differently. So now you're going to have EPA granting or denying the waiver based on an interpretation of the criteria in the Clean Air Act. And that's going to be subject to review by a judge, and that judge is not going to be bound to Chevron deference anymore.
And that judge will then get to decide, okay, your choice to grant that or to not was reasonable. I agree it was reasonable, or I disagree, and I get to be the one to decide.
But yeah, the judge is going to decide, okay, this is a reasonable construction of the statutory criteria, and did your application coincide with that reasonable construction?
Well, do you think, Prasad, just shifting to, for example, to CSA for a second, CSA is technically not a rule. Some would argue, though, it has the effect of a rule because of how the agency has implemented it. Do you think something like CSA could come under attack through this change in the rule with this ruling?
Yeah, I mean, I think that involves the larger question of, as you said, is CSA really a rule that has the force and effect of law? And I think there's a pretty good argument that it does not. That it's, I think, at least as FMCSA states it, it was a system put in place to prioritize who they should pursue enforcement actions against, or who they should visit for compliance reviews.
Right, and Congress never said, you should make this public for the whole world to digest. Right? They just said, you just need to prioritize based on, if I remember correctly, inspections and crashes. You can use that data to prioritize, but they never said, make it public, and they never said, score everybody against each other, and they never said a whole bunch of other things, right? So that...
Yeah, they talked about high risk, making sure you target high risk carriers, and yeah.
Yeah, but then the question is, okay, well, does that have the force and effect of law, that action? And I think that it's debatable.
Yeah. Okay, so in what ways is like the power of the judiciary now constrained? So more specifically, like if Congress said, and this is just an example, if Congress says, the federal government, you need to enact rules that limit the amount of time a driver can operate a commercial motor vehicle. And the federal government says, that you can only drive for 8 hours. They just decided that's our decision. Can a court sort of surgically go in and adjust the dials in that way to say, oh, you're a little low here, you're a little high here, I'm now the expert in the room? Like, what are the limits there? Does that make sense?
Yeah, so again, Congress has the authority to create the laws. The executive has the authority to execute the laws and make sure they are executed properly. The judiciary has the authority to interpret the laws. Now, under Loper Bright, the judiciary certainly has taken power that it may have once conceded to the agencies under the deference doctrine, but they certainly don't have the right to make up the law and change regulations themselves. So I think under that instance, if the court were to disagree that the agency has authority to enact a regulation that says you are limited to driving to 8 hours, then the judiciary would say this regulation is vacated and send it back for something else. I don't think a judge would be able to themselves. Say, hey, in my estimation, 10 hours seems better, so that's the new regulation. Now, you get instances where judges offer their views, perhaps improvidently, but they're not binding.
Got it. And just for the record, nobody's talking about an 8-hour driving limit. I just want to be clear about that. I was making up examples here. Don't want to make anybody upset. So
I guess, kind of in broad terms, is this a win for trucking? What do we think? What do we think? Any thoughts there? Is it still yet to be seen?
So I think the consensus right now is that this is a win for the regulated community. to the extent the regulated community feels they are overregulated and think that there should be more recourse. I think, obviously we all know trucking is a highly regulated industry. So the fact that there's not just pure deference to an agency rulemaking probably is helpful for the industry. But I think, we'll find out. There, as I said, it may bring into question if you're relying on a 1935 Act or a 1984 Act to address what am I going to do with autonomous vehicles. We may be in a lurch, and if the industry wants to start implementing autonomous vehicles, it's going to need Congress to fill the void.
It's an interesting,
We've seen how that's worked out.
Yeah, right.
Yeah. Well, that's one of the big concerns. I mean, we talked about sort of the context in which this decision comes down, and we have a Congress that hasn't in the last several years really done much, as far as legislating and regulating. And now it seems like the courts are going to ask them to do more. Which I think for those that think there's already too much government and that we need to slow that down, this is probably a win. But my faith in Congress's ability to effectively speak with one voice, let's say, even is not very high. So it'll be curious to know. I mean, I think there's a regulatory aspect and a deregulatory aspect here, and I think the deregulatory aspect is more likely to win in this. I mean, I'm not a lawyer, so I'm just, shoot from the hip here. But that's sort of my general take is that this is certainly more deregulatory than regulatory. Do you agree with that?
That's certainly the intent, yes.
Yeah. Well, I think at a minimum, it's not like we don't pay attention to this stuff already anyway, but clearly the industry needs to make sure that we're watching not only what the regulatory agencies are doing, but what Congress is, and get involved and be active at ensuring that you're sharing your views wherever it's appropriate at a minimum.
Yeah, it'll certainly be interesting to see how this impacts sort of the lobbying landscape and that sort of thing as we go forward, and we'll have to keep a close eye. There were several other sort of Supreme Court cases that made their way that may impact sort of administrative law, and we know that this Supreme Court has not been afraid to overturn precedent. So we'll have to see kind of how this goes moving forward. We're creeping up on the end of our time here, gentlemen. So I want to offer everybody an opportunity to sort of provide their final takes on what the impacts might be from this particular case and where Congress might go or the regulatory agencies might go in the future. But before I do that, I just want to thank everybody for being on the podcast today. This was and is an interesting topic. I think it'll continue to develop. So with that, I'll pass it over to Steve to maybe offer a last question or two and just say thank you to everybody.
Yeah, and thanks again, Prasad and Bill, for being on and sharing your thoughts and perspectives. I guess the last thing I'll question, any advice that you could offer to the industry about next steps here and what they should be paying attention to?
Well, so again, thanks for having me. I think you kind of maybe going back to the earlier question, is this a win for trucking, the trucking industry? I'd say it's probably a win for lawyers in the trucking industry. So what I would suggest
Congrats, Prasad, you did it.
So I think my recommendation obviously is there's a lot that's going to play out in the courts. So pay attention to that. But I think, as discussed earlier, it also reinforces the need to get engaged with the lawmakers in Congress.
Yeah, again, thanks guys. Appreciate the time today, and Prasad, thanks for educating me a lot. You've shared a lot of good information, and Steve and Sean, as always, great questions. As I look at it, I agree with you. I think, and I'm going to go back to, I really believe this is going to be a decade plus, as we observe kind of how the regulators and the courts respond to this new approach. It's a new organizational system, and there's got to be a lot of implications in terms of how this affects the management of policy making and enactment. So I agree with you, Prasad. I think the good thing about this is it starts to centralize, the importance of the policymakers, right? And so if you weren't involved before, you absolutely should be now. And I also believe as a business owner, it maybe slows a little bit, the progress of policy compared to innovation needs, but it also gives me maybe a little bit more stability that doesn't change every 4 to 8 years, which I think could be a positive if I'm an owner, whether I'm an owner operator or an owner of a motor carrier, trucking company, logistics company. It at least gives me a little bit more stability than kind of jumping side to side in terms of how policy and rules are interpreted or enacted. So we'll see. It's going to be an interesting next decade here. I hope ultimately there's a positive kind of win for the trucking industry. And, like anything, there's going to be some positives and probably some unintended consequences here. But at the end of the day, we at least maybe have more clarity now of who's ultimately accountable, and that's going to be our congressmen and women.
That's a really good point, Bill. I think, that last point you made, unlike many other industries, transportation cannot handle whiplashing back and forth, right, on rules and policy. And that stability point, I think, is very, very astute for you to make that point.
Awesome. Well, we'll see how the flip-floppers do then. Long run, hopefully it'll calm down. We know Prasad won big with this decision. Thank goodness. So that's really great. But certainly agree that we vest power in Congress, and so they should do their job to the best of their ability, and maybe this will encourage them to do that instead of to kick the can. But we'll have to see. So anyway, thanks everybody for being on the podcast. Really appreciate you. As always, anybody out there listening wants us to cover particular topics, please don't hesitate to reach out, and we're just pleased to be here. So thanks to True North for all your support here, and we'll see you next time.
Thanks for listening to this episode of True North Truck Thought. If you enjoyed the topic today and want to tune in for future conversations here on the Triple T Pod, make sure to follow us. Also, please don't hesitate to let us know which topics you want us to cover in future episodes. Drop us a line in the comments section or send us an email to transportationnews@TrueNorthCompanies.com. Thanks and have a safe day.